Immigration and the employment of immigrant workers are controlled by a series of federal laws. In general, these laws are designed for two purposes: to require verification of the legal right to work within the United States and to prevent potential discrimination against immigrant workers who are legally allowed to work in the country. The two major laws in this area are the Immigration and Nationality Act of 1952 as amended and the Immigration Reform and Control Act of 1986. While immigration law is extremely complex, for our purposes, in an introductory to HR type course, we'll discuss only the basic employment provisions of these two laws. Immigration and Nationality Act of 1952, known as the INA. The INA is designed to take a variety of different immigration laws and combine them into a single act. Before INA, a number of federal laws governed immigration, but they were not consistent and were not organized in one location under one authority. The INA allows companies in the United States to employ immigrant workers in certain specialty occupations through the use of an H-1 visa. For example, foreign workers, such as engineers, teachers, computer programs, medical doctors, and physical therapists, may be employed under the H-1B program. However, specific requirements apply to such employment, and there are annual limits on the number of workers who can apply for work visas in these specialty occupations. Because Congress foresaw the potential for companies to discriminate against all alien workers to avoid any accusation of hiring undocumented workers, INA also has a non-discrimination requirement when dealing with alien workers who have the right to work in the United States. The Immigration Reform and Control Act provides that employees may hire only individuals who are authorized to legally work in the United States. The Immigration Reform and Control Act has a provision that prohibits employers from knowingly hiring undocumented workers, and it requires employers to verify each employee's eligibility for employment. The employer is required to verify the identity and employment eligibility of anyone it hires through the use of a form called the Employment Eligibility Verification Form, otherwise known as Form I-9. However, the Act also provides employers comply with in good faith requirements of the Immigration Reform and Control Act, with what's called an affirmative defense to inadvertently hiring unauthorized aliens. An affirmative defense means basically that if we made a legitimate and complete effort to verify a person's legal status, and it turns out that the person provided false documents, or that we were tricked or lied to in some other way, we won't be held liable for any potential fines that would have otherwise been assessed for hiring undocumented workers.